First of all, Kimmy, thank you for joining us today. And thank you to our entire WireWheel team for all you've done to put together this fantastic winter 2021 version of Spokes. We're really proud of what WireWheel and the Spokes community has done. I'm going to run through the full agenda towards the end of the session today, and it's a fantastic session filled with learnings on a number of important subjects for the community. But I'd like to start today by welcoming Bruno Gencarelli, our frequent collaborator here at Spokes and head of a lot of different topics for the European Commission when it comes to data and data transfers. Bruno, welcome back to Spokes. Thank you for joining us.
Thank you, Justin. Thank you for having me.
Well, Bruno, it wouldn't be a session at Spokes if I didn't start by, there's a lot going on in the world of international data transfers. And we have about 30 minutes today, and I know we're not going to be able to cover all of the subjects I'd like to discuss with you. But one of them that's of a lot of interest to folks around the world is the current discussions around what is currently called Privacy Shield, the EU-US Privacy Shield. Would you mind giving us a little bit of an update on where things stand on the discussions around a new framework for data transfers between EU and US?
Sure, and thanks for that question. I'll try to be brief because indeed we don't have much time and there are many topics, and the word of data flows is a diversified word which doesn't stop at the transatlantic dimension, although that's of course a core component of that issue. Privacy Shield, successor arrangement to the Privacy Shield is clearly a priority on both sides of the Atlantic. I'm sure that if you speak to my colleagues in DC, they will say the same. Second message, meaning we want a solid, a durable, a sustainable framework. What's the secret recipe to get there? Well, a framework which fulfills the requirement of the Schrems II judgment, which is quite detailed, and that's a certain change and evolution between the two judgments, is quite detailed on what is expected in terms of safeguards when it comes, that's the aspect on which we're working when it comes to governance access to data, in particular governance access to data for national security purposes. And that's not an easy issue. It's not and it's a complex balancing act in the US as it is here, as it is in any modern system around the world. However, I believe we have made good progress, and I'm not just saying that for the sake of it, but we have made good progress on a number of issues we have to cover. We are now really intensively negotiating. We are no longer in a sort of exploratory phase. We are now really working on texts, exchanging texts, exchanging ideas, exchanging possible solutions. So a lot of progress, a lot of good progress, but we are not yet there, which is not surprising. I think that nobody thought that a couple of months or a bit more would be sufficient to get there. Again, we share the sense of urgency, but also we share, and I think that's also very well understood by my counterparts in Washington, that the question, although I guess the question of you, Justin, and your audience is when, the what is more important than the when, in terms of making sure that this is an arrangement that certain will say for once will pass all the necessary tests, including litigation, if that takes place. So I would be very happy to conclude those negotiations tonight if we can say that we can confidently defend this as fulfilling the relevant requirements. We are not yet there. The Commissioner Reinders who is the European Commissioner for Justice, will be in Washington next week for other matters, but it will be offer him also an opportunity to take stock on the negotiation and discuss the way forward. There are regular negotiating sessions and meeting. We're working hard on this, and we will work, I guess, even harder because certainly we understand the importance of concluding this negotiation and concluding this negotiation successfully.
So Bruno, I know that there are limits to what you can talk about, and certainly I understand the delicacy in the middle of a discussion. So I understand if we can't go into any of these, but if you don't mind, I'll sort of follow up with a few points. The Schrems II decision was mid last year, 2020. So you're talking July 2020. Privacy Shield is used by a lot of small and medium-sized companies, for example, to comply, to do more than might be relied on under US law, for example, in order to avail themselves of a special transfer benefit from Europe. Now, that's a long time for small and medium-sized companies. I'll ask three quick questions again in our short time. Do you have any sense of timing on when at least a framework agreement might be reached? We're never going to hold you to it, nor could we, because even after there's a framework agreement, there's a process to follow, including going through the trilogue and getting the new adequacy. So, there's a pretty long tail. So do you have any sense of timing? I get this question a lot. If there's a new privacy shield, or whatever you're going to, the new title may be, will there still be the need to do transfer impact assessments? For example, that's a separate one. Will it still be called Privacy Shield? Do you have any sense of the title or name to it? And then finally, are the discussions and negotiations still focus on redress for national security purposes? Is that the exclusive area of negotiation at this point, or is it broader than that?
Okay, well, that's a lot.
We only have a few minutes with you.
Yeah, we could spend the afternoon or the evening, depending, or the morning, depending on where you are. So I've tried to take note very quickly of what you said, but please remind me if I forget anything. First, the title, the name. That's, if we were at that stage of the discussion, call it. We could do with the support of Wirewheel an open competition, an online competition on the title. That's of limited importance, and for the moment this is not being discussed, and I don't know if it will have another name. We will see. But what is important is the nature of the instrument. It will be an adequacy decision, and that will, if we succeed, and that will have a major benefit, in particular in the post-Schrems II environment. It means that it will, of course, based on, as we know, certification with the Department of Commerce, but it will mean that indeed companies will be able to rely on the new arrangement to export data to the US. From the EU to the US, and to import data in the US from the EU, without having to enter into that case-by-case type of assessment that the Schrems II judgment requires when using alternative transfer mechanisms. So that's in terms of stability, in terms of costs, it's in terms of simplicity, in terms of straightforward nature of that, but it is an enormous benefit, and that's why we are very much developing adequacies, including with other countries in the world. So that will be. So the short answer to your question on the transfer impact assessment is no, but yes, because in any case, as you know, and that's part of, I guess, the core business also of Wirewheel as other companies, when you handle data, you need, regardless of Schrems II and regardless of transfers, to know what you're doing, and to map your processing, and to indeed know what you're doing with data. that's a key compliance and accountability aspect that will always remain. I don't think necessarily first of all for regulatory questions, but first of all, I guess for minimizing risk and optimizing business opportunities arising from data. So that's
Bruno, if I may, on that one point. So if I were to rephrase it, you can agree or disagree. If there's an adequacy finding under a new Privacy Shield or Privacy Shield successor, that means the technical transfer impact assessment portion in which you have to evaluate the sort of regime that you're transferring it to with respect to the US, companies would no longer have to conduct. They still would have to do a normal assessment of processing activities just as normal. But
the answer is yes, correct, because an adequacy decision is an act, a legal measure adopted by the EU, by which the EU says, we have done that assessment, and for us, things are okay, if you want, green light for transfer. And of course, has the benefit of giving full access to the internal market. And let's not forget that the key benefit of an adequacy decision is that simplicity, and also is one of the very few tools we have in EU law to extend the benefit of the internal market to a foreign jurisdiction, so that movement of data between the EU and a foreign country are more or less treated as movement of data between two member countries of the EU. You had another question on redress and what is being discussed. Yes, redress is a main issue. There are essentially two issues in Schrems 2. One is what are the conditions, limitations, safeguards on the basis of which data can be accessed by intelligence agencies, for instance, when it has been in the first place transferred for commercial purposes. That's one issue. And I would say that's an issue which I think we can say we have made good progress around principles that might be called differently in different jurisdictions, but are essentially necessity and proportionality. That there's a certain nexus between the data which is being accessed and the national security threat that is being addressed, and also a certain reasonableness, to use a US term, in the nature and the amount of data being collected. And then there is the question, which is not an easy question, but a fundamental question, because that's also the question on which the Court of Justice has been the clearest and the more and the most detailed, the question of the possibility for individuals to invoke or allege a violation of those safeguards. The two aspects are linked, of course, a violation of the safeguards between a court, between a tribunal, between a judicial redress body. So that's those are the two questions we are dealing with. You seem to suggest from the question that you think that the second aspect is more or difficult, or the most difficult. I'll leave that comment to you, but I can confirm it's a difficult aspect. Yes.
Well, okay. Well, so then the point I would follow up on then, right now, companies that are maintaining their compliance with the Privacy Shield principles without getting the benefit of a means of transfer, is the expectation that if there's a new Privacy Shield, that companies, if they continue to do what they've already certified to, will get the benefit of the means of transfer? Or do you anticipate there's going to be new requirements that are commercial, or different requirements from a commercial perspective?
So a question with different answers, indeed, and thanks for recalling that. I know that certification continue and are either new certification or probably certifications are renewed on the US side. It's very important to say that in terms of compliance with the GDPR, with the GDPR requirements, those certifications are of no value for the moment. the privacy shield when it comes to.
Well, there's some value to humanity, Bruno. To humanity, there's benefits, right? I know,
Yeah.
I'm just teasing. I know they don't get the benefit of a means.
You know, I will also be teasing. You know, for us, from a European side, the privacy shield is dead. Meaning, but you know, we believe also in resurrection, and that's what we are working on. So, but what I want to say is that we are, meaning, jokes apart, your question is aiming at an important point, which is that we are working on the governance access part of the deal, because that's what has been quashed by the Court of Justice. Those are the grounds for which, on the basis of which the Court of Justice invalidated the privacy. The so-called commercial part, which is what matters in a daily life, in the daily life of businesses, which requirements I have, which additional requirements I have to comply with to benefit from that instrument, are not touched by these negotiations, or to a large extent. Let's say if there would be changes, they would be quite minimal. So yes, the idea is that, you know, you have the privacy shield. Let's move from the image of a shield to the image of a house. The privacy house has two floors: the commercial floor and the government access floor. The government access floor, for the moment, is in renovation repair. Once we will get that, then the two floors will be connected again, and companies will be able to enjoy the benefits of that instrument, including for transfers.
Well, look, terrific. And you know, again, I'm sure there have been widely reported, you know, discussions and back and forth on the proposals that have been coming from the US and from the Justice Department to assist on the redress side, including that, you know, again, I have no inside information on this, but just what's been reported is different versions of judicial panels that have been proposed as attempting to meet the redress side. By the way, I don't mean to suggest the redress element of it is any more difficult or less difficult than the necessity and proportionality, and clearly they're tied. But the redress part of it has some very difficult, if I may say, technical aspects when you try to reconcile it with the elements of standing and judiciability under US law. So there's some tricky elements to that, Bruno. Can you comment on where things stand in terms of the proposals that have been coming from the Department of Justice and from other parts of the government? And what is the gap at this point? I know you can't comment specifically, but is that still the core area of focus in terms of the redress portion of it?
Well, I really cannot enter this, also because you have worked in government, and you know also a number of confidentiality requirements that apply in particular to international negotiation. This is also a question of trust between different parties involved in the negotiation. But what I can tell you is that we want a system that works in both systems. We want a solution, that works in both systems. We are working within the US system. Each system is constructed and structured differently. This question of standing are, of course, very important. And by the way, there's recent case law from the Supreme Court that also says to the legislator, there are things you cannot do there in this area. There are limits. We have also seen that there are redress mechanisms that exists, of course, that involve the judiciary branch. There are redress mechanisms within the executive branch. There are possibility probably also to combine the two. There are many ways, and redress in an area such as national security is, of course, subject to legitimate limitations to fully take into account the sensitivity and confidentiality of issues that you that might be involved in that type of litigation. What I want to say is that you don't litigate in the national security area like you litigate in the commercial or even in the criminal law area. So those constraints that exists, once again, on both sides of the Atlantic are well understood. That said, we will be tested also because that's the easiest part of this saga to understand. Whether an individual has access to something which is a court or tribunal, which has the independence, the permanence, the impartiality that everybody would expect in the US, in the EU, in any modern system of a adjudicating body such as a tribunal. That's what we need to work on. There are different ways to get there. And I guess that's what I can say.
I understand. And again, I don't mean to go into the details of the negotiation, and I understand the limits there, Bruno. You know, we only have a few minutes. There's a lot of other subjects I would like to cover. I'll just say, would be really interested in understanding or hearing from you on sort of developments on data transfer frameworks in addition to the US. I know we never hit the timing question on Privacy Shield, so maybe you can't comment on that, which is fine, but I'd love to hear about any other color there, anything, you know, updates on sort of discussions with the UK. And then obviously there's constantly a series of discussions that have been, must be in progress under other regimes, you know, in terms of adequacy decisions, Bruno. So if I may ask, would you mind commenting on anything you feel like you can cover there?
So 4 minutes for the rest of the world. It gives a good idea of balance here. 26 minutes for the US, 4 minutes for the rest of the world. Anyway, and actually, I will still speak about the US. In terms of timeline, as I said, you need to tango. I simply can say that we are committed on both sides of the Atlantic. I would, in negotiation, you don't fix deadlines. You have objectives to fulfill. We have conditions to fulfill, so requirement to fulfill, and we hope we can get as soon as possible there. But I'm not in a position today to tell you when. And rightly so, you have that even when we will have announced a deal, there will be work on both sides. We will have to go through our decision-making process, opinion of the European Data Protection Board, which is the board that brings together our regulators, a green light from our member states, the countries that compose the Union. And on the US side, also looking at what we are discussing, it will require some implementation. This is not something that will be implemented overnight. But as I said, this is, I can tell you why I'm speaking here. Some people and my colleagues and my teams are doing the real work, and you can be sure that we are committed. On the rest, on the other transfer tool, first, in terms of adequacy decisions, yes, this is, especially in the post-Schrems II environment, this is for us a very important tool, the tool that can provide stakeholders the certainty, the stability we owe them and they deserve. That's why we have also a more strategic approach to adequacy. We think also that there are many more opportunities as countries are converging. Adequacy, it's not about identity, it's about converging on a number of common safeguards. And that's why, for instance, after having created the biggest area of data flows in the world with Japan, we have concluded this year our adequacy negotiations with Korea, and that's a scoop for your audience. If everything goes well, it will be adopted by the EU next week. So by the end of the year, free flow of data between the EU and South Korea. We are working on similar deals with a number of countries in Asia and Latin America, for example. You've mentioned the UK. The UK, the two adequacy decisions we adopted with the UK were a very important part of, I would say, are a very important part of the post-Brexit relationship, one on the GDPR and the other one for law enforcement cooperation. There are movements in the UK that we are they are observing very closely. We hope that they will not put into question the level of protection we found as adequate. But then what is very important is that beyond that bilateral dimension, we're working on a number of tools which can also cover regions and have this sort of critical mass or network effect. First, model clauses. Model clauses are now adopted and used as part of that convergence by a number of jurisdictions around the world. We've seen Switzerland, who has adopted the same model clauses we have adopted. The UK has proposed a version which adapts to the UK the new standard contractual clauses. We see other jurisdictions, New Zealand, for instance, not exactly the same model clauses, but model clauses that present some important commentaries. And then, as I said, we see regional organizations, ASEAN, the Association of Southeast Asia, countries as important as Singapore, Indonesia, Malaysia, and many others, has adopted its set of model clauses to facilitate transfers within the region, but we believe also that this is useful to facilitate transfers between that region and the rest of the world. We're working with ASEAN to build on the commonalities and to bridge our different set of, meaning our respective sets of model clauses. I think that's a very interesting development that would capture many jurisdictions and help companies, really help companies and cut in compliance costs of companies active in both jurisdictions. The same is happening with Latin America. We are also working on underdeveloped, for the moment, transfer mechanisms such as certification. In the EU, we are working in these days with the EDPB, the European Data Protection Board. We are co-responsibility. We are co-responsible for that under the GDPR to make sure that finally in the course of next year, rather the first part of next year, those will be in place. And let me finish with maybe an aspect which is not so often mentioned, and which is a very important aspect of our policy: how to work how to create synergies with different instruments. We deal with the flows of personal data through the instruments provided under the GDPR, but that's not the end of the story, of course. There are obstacles to data flows which have nothing to do with the protection of privacy. They might sometimes use the protection of privacy as an excuse, as a pretext. I'm thinking about a number of data localization requirements we are increasingly seeing the world. So for now, in all our trade agreements, and we are negotiating a lot of trade agreements with countries such as New Zealand, Australia, Indonesia, Tunisia, Chile, and others. At the multilateral level, we are, of course, negotiating the e-commerce. We are in the e-commerce negotiations at the WTO. We propose an approach based on a straightforward prohibition of data localization requirements. It's not always an easy square to circle, the difference between genuine data protection and data or digital protectionism, but it is something that on which we are very engaged with a number of international partners.
So Bruno, first of all, I mean, in the last 4 minutes, you covered a number of very important subjects. I know you were under a time restriction today. I think announcing that there is an adequacy decision with respect to South Korea is obviously very important. Just on that one point, is it an adequacy decision as to the country, or is it a specific country specific? So that's not a framework like a privacy shield. It's a determination that South Korea has an adequate regime, essentially equivalent to the EU. Is that correct?
Like we did for Japan, and even a bit broader, because we're covering also the public sector, which is not so important maybe for you and your audience, but which is very important in terms of regulatory.
No, that is very important. And again, like there's a number of subjects I would love to follow up on. The Latin area transfer frameworks and others would be terrific to cover. And we didn't even get to cover things like the recent EDPB guidance on transfers, but perhaps that gives us a reason to invite you back soon if you'd be willing to join us back sometime, Bruno, to cover and follow up.
With pleasure, Justin. And see you soon.
Thank you very much for sharing these insights with us today, Bruno. Good luck on the discussions on both sides, and around the world, we are rooting for everybody to come to a new framework. And thank you very much, as always, for joining us.
Bye-bye.
Bye-bye. And thanks so much for joining us, Bruno. For everybody else, I know we have to jump straight into our speaker today, and I want to make sure I cover the incredible sessions that Wirewheel and our team at Wirewheel have put together for the rest of the day. Our next session begins at 11:30 Eastern Time. Third-party risk is everywhere. A fantastic session that begins at 11:30 and hosted by BBB National Programs. Josh Harris will be hosting with CJ Utter and Kelly Peterson Miranda from Amazon. At 12:30 Eastern, a very, very topical subject, the metaverse, privacy in the metaverse and what you need to know today. Our very own Rick Buck will be leading that panel, hosting the panel, with Jennifer Vancini from Mighty Capital, Christy Steele from one of our lead investors, Sands Capital, and Jeremy Greenberg from the Future of Privacy Forum. That's at 12:30 Eastern. Really, really important subject. At 1:30 Eastern, we have a panel of phenomenal privacy operations leaders. And as we all know, there's a really strong practice growing around the country with our leaders who actually run privacy programs. And we have three fantastic leaders, Rebecca Shore, who's the Chief Privacy Officer at Albertsons, Rochelle Bastarche, who's the Associate Legal Counsel at Shopify, and Netta Beserki from Apple Bank, and with a panel that's actually hosted by Virginia Bartlett from here at Wirewheel. 11:30, we have a panel on vaccine requirements, biometrics, and the challenge of managing employee healthcare data. That's with Robert Glazer hosting from Antisys 360. We have speakers from Agilent, 98.6, TriNet, and Boehringer Ingelheim. Digital advertising. This has become, again, a tricky subject with different global laws around the world. Our partners at IAB Tech Labs, Michael Hahn, the general counsel, will be hosting a panel. Really a phenomenal set of experts. Jessica B. Lee of Loeb & Loeb, Mark Weber of Field Fisher, Jessica Rich of Kelly Dry. Jessica, of course, came most recently from the FTC, and Sophie Dawson of Bird & Bird. And then we close the day at 4:30 p.m. with a panel on explaining AI, how to implement explainability under the various global AI and ML regulations. Lee Matheson from Future of Privacy Forum, together with Sarah Jordan, also of the Future of Privacy Forum. And we'll have Data Privacy Brazil represented by Renato Montero and Christina Montgomery of IBM. So just a fantastic group of panels today. I look forward to seeing everybody starting again at 11:30. And thank you again to Bruno Gencarelli for a terrific introductory keynote. An announcement today, an important one, that the EU has reached agreement with South Korea on an adequacy finding. That'll be an important finding for companies doing business in the EU and South Korea especially. A discussion that was important on regional frameworks that the EU is working on, including in Latin America, and an important set of updates on the Privacy Shield discussions, which are as we know, still ongoing. So thank you again to Bruno for joining us today. Thanks to all of you for joining us here at the Spokes Conference. And on behalf of the entire team at Wirewheel, we'll see you starting again at 11:30. Thank you.